Hello dear students, the topic for our session is implied authority of a partner. Let us begin the meaning of what is authority. What is authority? The word authority, derived from the Latin word authoritas, can be used to mean the right to exercise power given by the state in form of government, judges, police officers, etc. By academic knowledge of an area, someone that can be an authority on a subject. What are the types of authority? First one, actual authority. Actual authority includes express authority and implied authority, not to be confused with implied appointment, that is appointment by estoppel. Generally, actual authority is used synonymously with express authority. Express authority is the authority which the principal has expressly given to the agent, whether orally or in writing. Implied authority, sometimes described as the usual authority, is the authority of an agent to act which are reasonably incidental to and necessary for the effective performance of his duties. The content of implied authority depends on the facts of each case and is sometimes determined by the usages and customs of trade, business or profession. The scope of the actual authority of the agent is therefore to be ascertained from the oral or written agreement between principal and agent, usage and customs of relevant trade, profession or business, and the course of dealing between two parties. If the agent enters into a contract with the third party pursuant to his actual authority, the contract entered into will create contractual rights and liabilities between the principal and the third party. Apparent or ostensible authority. An agent is said to have apparent or ostensible authority if the principal has made a representation, whether by words or conduct, to the third party to the effect that the agent has the authority to act for him, although the agent does not in fact have such authority. The third party is in fact relied on such representation to deal with the agent, and the third party has altered his position resulting from such reliance, for example, assuming obligations under contract with the agent. In a sense, apparent or ostensible authority is authority which the principal induces a third party to believe the agent has when the agent is in fact has not. The agent has only the appearance of authority but no actual authority to act on behalf of the principal. Nevertheless, if the third party enters into a contract with the agent in reliance on the principal's representation, that contract will still be legally binding on the principal. Apparent or ostensible authority will give rise to agency by estoppel, discussed in section 3 subsection 2 above. The principal's representation to the third party as to the authority of the agent to act on his behalf, when acted upon that third party by entering into a contract with the agent, operates as an estoppel which prevents the principal from denying that such contract is binding upon him. Now let us study in detail the meaning of implied authority with examples. Implied authority. Implied authority, also known as usual authority, is the authority of an agent acting on behalf of another person or entity. The person acting with implied authority does what is reasonably necessary in order to effectively perform his duties. The act undertaken surrounding the use of implied authority depends on the circumstances and the case. To explore this concept, consider the following implied authority definition. Definition of implied authority: authority that is not specifically expressed or defined in writing, but which an employee or an agent assumes to possess in order to conduct the business on behalf of the agency. Implied versus actual authority. Actual authority, as referred to as express authority, pertains to specific powers given to an agent in oral or written contract. This differs from implied authority in that implied authority has been assumed because of the circumstance. For example, when an employee or agent wears an uniform, name tag, or has a business card bearing the trademark or logo of a company, that individual carries implied authority. This is because consumers are likely to assume the individual has authorization to act on behalf of the company. The same would be true of an employee sent by a company or agency to make repairs. Even if the employee wore no uniform or name tag, because implied authority is often incidental, it is impossible to define every single aspect of the agent's authority in a written contract. Example of implied authority: A and B carry on business in partnership as bankers. A sum of money is received by A on behalf of the firm. B does not know of the receipt. A appropriates the money to his own use. The partnership is liable to make good the money because receipt of the money by A is in usual course of business. A partner in a firm of solicitors, borrows money and executes a promissory note in the name of the firm without authority. The other partners are not liable on the note, for it is not part of the ordinary business of a solicitor to draw, accept or endorse negotiable instruments. A and B are partners. A, with the intention of cheating B, goes to a shop and purchases certain articles on behalf of the firm, such as might to be used in the ordinary course of the partnership business, and converts them to his private use. There being no collusion between him and the seller, the firm is liable for the price of the goods. When John visits a local bar, the server tells him he will receive a free drink if he orders an entry. By making this offer, the server has made an oral contract with John on behalf of the bar. John assumes that the server has the authority to offer a free drink since he is an employee of the business and acting on behalf of the owner. Now, let us study the liability in actual and implied authority. When an agent acts on actual authority, the scope of which is outlined in a written document, both the agent and agency may be held liable the results of such actions. When an agent acts on the implied authority, however, the scope cannot be specifically determined, and so liability becomes a fuzzy issue. The employer or agency may claim the agent acted outside his authority, leaving the agent holding the bag. Now let us study the termination of implied authority. At any given time, an agency can take implied authority away from an employee. This can be done in several ways, including: 1. Amending a contract or agreement taking away authority. 2. Ending the agent's employment. 3. Discharging the agent of an obligations. Now let us study the implied authority of a partner as per Indian Partnership Act of 1932. Introduction. Capacity of a partner to bind the firm by his acts is called authority of a partner. Every partner is the agent of the firm for the purpose of the business of the firm. Section 18. The partners and the outside world, whatever may be their private arrangements between themselves, each partner is agent of every other in every matter connected with the partnership business. His acts bind the firm. He can act on behalf of the firm and bind the firm provided he does the act for carrying on in the usual way business of the kind carried on by the firm, and the act is done in the name of the firm. Section 19(1) and 22 read together provide that the act of a partner which is done to carry on in the usual way business of the kind carried on by the firm binds the firm provided that the act is done in the firm name or in any manner expressing or implying an intention to bind the firm. Such an authority of a partner to bind the firm is called implied authority of a partner. Therefore, the test to judge whether a transaction entered in by a partner comes within his implied authority is quite simple. For successful application of this test, these three conditions must be fulfilled. Absence of even one condition will vitiate the transaction and will not come under the ambit of implied authority of a partner. These conditions are: the nature of transaction to carry on business of the kind carried on by the firm, the manner in which the transaction has been transacted, is it done in the usual way, in whose name the transaction has been done, it done in the name of the firm, or is the intention to bind the firm clear. Thus we can say that it is subject to these conditions. 1. The act done by the partner must relate to the normal or usual business of the firm. If it is of a nature which is not common in the type of business carried on by the firm, It will not bind the firm even if it has been done in the manner of the firm. For example, a partner of a firm dealing in books places an order for a certain quantity of wine in the name of the firm. The firm would not be liable, and the case would be of Mathura Nath Chowdhury vs Bhageshwari Rani and other. A partnership firm was engaged in trapping wild elephants. A partner hired an elephant from B who died while being in use of the firm. B claimed rupees 5,000 was promised to him. One of the partner wanted to escape the liability on the ground that act of the other partner was not necessary and usual in carrying business. It was held that the act was within the implied authority of the partner. Second, the act must be such as is done within the scope of the business of the firm in the usual way. It is difficult to lay down any foolproof rules as to what the usual way of carrying on the business is. It will depend on the nature and circumstances of each particular case. In other words, the acts should be such as is usual in the type of business carried on by the firm. For example, buying and selling of goods, drawing and accepting bills of exchange, taking loan, etc. are considered normal activities in a trading concern. Third, the act must be done in the name of the firm or in any other manner expressing or implying an intention to bind the firm, section 22. If there is no implied or expressed intention that the act is being done for the firm, then it will not be binding on the firm. Every partner has an implied authority to bind the firm by the following acts. He may sell the goods of the firm. He may purchase on the firm's behalf goods of the kind usually employed in the firm's business. He may receive payment of the firm's debts and give receipt for them. He may engage servants for the partnership business. Accept, make and issue negotiable instrument, checks, bill of exchange, promissory notes in the firm's name. Borrow money on the firm's credit and pledge the firm's goods to effect that purpose. Buy goods on credit for the firm. Engage and instruct an advocate in a suit by or against the firm for a trade debt. A trading firm is one which carries on business of buying and selling of goods. Examples: A, the partner of a firm of confectioner, buys sugar on credit in the firm name. The firm is bound to pay for the sugar. A, the partner of a firm of bankers, accepts a bill of exchange on behalf of the firm, does not inform the firm of this receipt, and afterwards the money is appropriated by A for his own use. The firm is liable to make good the payment. A, the partner of a firm of confectioners, buys a horse on credit in the firm's name. The firm is not bound to pay the price of the horse, as this act does not fall within the scope of confectioner's business. B, the partner of a firm of solicitors, accepts a bill of exchange on behalf of the firm. The firm is not bound to pay the bill, as it is no part of ordinary business of the solicitor to draw, accept or endorse bill of exchange. However, a partner has no implied authority unless otherwise expressed in the partnership deed in the following matters: acts beyond implied authority, section 19. To submit a dispute relating to the business of the firm to arbitration, as it is not the ordinary business of the partnership firm to enter into the submission for arbitration. To compromise or relinquish any claim or portion of a claim made by the firm. To withdraw a suit or proceeding filed on behalf of the firm. To admit any liability in a suit or proceeding against the firm. To open a bank account on behalf of the firm in his own name. To acquire or purchase immovable property for and on behalf of the firm. To transfer or sell immovable property belonging to the firm, and to enter into partnership with others on behalf of the firm. Now let us study about the implied authority and third parties. Extension and restriction of a partner's implied authority, section 20. The partners in a firm may be contract between them, extended or restrict the implied authority of any partner. So far as the third party is concerned, the firm continues to be liable to him for any such act which falls within the scope of the implied authority of a partner, unless the person with whom the partner is dealing either knows that the partner has limited or no authority, or does not know or believe that the partner to be a partner. The third party is also not affected by a secret restriction of the implied authority of a partner unless he has notice of it. However, the implied authority of a partner may be extended or restricted by a contract between the parties. The partner can undertake the above mentioned matters where he has specific or express authority of a partner by agreement. The usage or custom of trade permits him to do so. All the partners of the firm can ratify an act of the partner which has been done by him in excess of the implied authority or without any authority, provided the act is such as could be legally done with the authority of all the partners previously given, and the partners ratify the act with full knowledge of the facts. SN Soni versus Tawfiq Farooqi, AIR 1976, Delhi. Such ratification can be proved by the conduct of the partners. Ludaram Ved Prakash versus Messrs Maharani of India, AIR 1989, Delhi 169. Thus, a partner has implied authority to bind the firm by all the acts done by him in all matters connected with the partnership business, and which are done in the usual way and are not in the nature beyond the scope of partnership. You must remember that an implied authority of a partner may differ in different kinds of the business. If partnership be of general commercial nature, he may pledge or sell the partnership property. He may buy goods on account of the partnership. He may borrow money, contract debts and pay debt on the account of the partnership. He may draw, make, sign, endorse, transfer, negotiate and procure to be discounted. Promissory notes, bill of exchange, checks and other negotiable papers in the name and on account of the partnership. Under the following conditions, the restrictions imposed on the implied authority of a partner by agreement shall be effective against third party. The third party knows about the restriction, and the third party does not know that he is dealing with a partner in a firm. Rights in an emergency. In emergency, a partner has authority to do all such acts for the purpose of protecting the firm from losses as would be done by a person of ordinary prudence acting under the similar circumstance as in his own case, and such acts bind the firm, section 21. For example, A partner borrows from B rupees 1000 in the name of the firm, but in excess of his authority, and utilizes the same in paying off the debts of the firm. Here, the fact that the firm has contracted debts suggests that it is a trading firm, and as such it is within the implied authority of A to borrow money for the business of the firm. This implied authority, as you have noticed, may be restricted by an agreement between him and the other partners. Now, if B, the lender, is unaware of this restriction imposed on A, the firm will be liable to repay the money to B. On the contrary, B's awareness as to this restriction will absolve the firm of its liability to repay the amount to B. You should further note that the above mentioned extension or restriction is only possible with the consent of all the partners. Any one partner or even a majority of partners cannot restrict or extend the implied authority. 2. Effect of admissions by a partner, section 23. Where a partner makes any admission or representation concerning the affairs of the firm, it is sufficient evidence against the firm provided the admission or representation is made in the ordinary course of the business. This follows from the general rule that the partners are agents of each other for purpose of carrying on the business of the firm. But if the admission or representation is made by a partner beyond the scope of his authority, the firm will not be bound by it. 3. Effect of notice to be an acting partner, section 24. Notice to a partner who habitually acts in the course of the business of the firm of any matter relating to the affairs of the firm operates as notice to the firm except in the case of a fraud on the firm committed by or with the consent of that partner. This follows from the general rule that a notice to an agent of matters relating to his agency is notice to the principal. Example: A and B are partners in a firm dealing in junk. A purchases on behalf of the firm a discarded lorry from C. A learns in the course of this dealing with C that lorry does not belong to C. A and B are both liable to the true owner. 4. Liability of a partner for acts of the firm, section 25. Every partner is liable jointly with all the partners and also severally for all the acts of the firm done while he is a partner. The significance of joint and several liability is that for every act of the firm, a partner can be sued individually and also jointly with other partners. 5. Liability of the firm for wrong acts of the partner, section 26, whereby the wrongful act or omission of a partner acting in the ordinary course of the business of the firm or with the authority of his partners, loss or injury is caused to any third party or any penalty is incurred, the firm is liable therefore to the same extent as the partner. Examples: H, a partner in a firm whose business was to obtain by legitimate means information about the business contracts of competitors, bribed the clerk of a rival firm to give secret information about his master's customers and prices. Consequently, the rival firm lost the business to the tune of £750. Held the firm was liable in damages to the competitor. Hamblin vs. Houston and Company, 1903, 1 KB 81. The managing partner of a coal mine was guilty of personal negligence in omitting to have shaft of the mine properly guarded as required by law. As a result of this default, a workman fell into the pit and was injured. Held the firm was liable. Melsers, Sean, 1861 B and S 437. A appointed a firm consisting of partners B and C to buy and sell wine for him on commission. A left money with the firm for the purpose. B, the active partner, rendered false accounts of purchase and sale to A and misappropriated the money. Held the firm was liable. Rapp vs. Latham, 1819, 21 RR 495. A and B are partners as solicitors. C, a client, entrusted some money to B to be invested in specific security. B made away with the money. A was however ignorant of the transaction. Nevertheless, he was held liable, for it is within the ordinary scope of a solicitor's business to receive money to be invested on specific securities. Blair vs. Bromley, 1847 to ph 354. Liability of a firm for misapplication, section 27. A firm is liable to make good the loss where a partner act within the scope of his apparent authority, receives money or property from a third party and misapplies it, or the firm in the course of his business receives money or property from a third party and the same is misapplied by any partners while it is in the custody of the firm. Examples: M applied to R, a member of a firm of solicitors, to raise a loan on the mortgage of his freehold estate. R arranged for the loan but falsely informed that the lender required some additional security. M accordingly deposited with R some share warrants payable to the bearer. R subsequently sold the share warrants, misappropriated the proceeds and absconded. Held the other partners were liable for the misappropriation, as M's share warrants came into the hands of R when he was acting within the scope of his apparent authority. Rhodes vs. Mules, 1895, 1 Chapter D, 236. A partner of a firm of bankers disposed of certain securities deposited with the firm by a customer for safe custody. Held, all the partners of the firm were liable. Devins vs. Noble, 1862, 1 Merck, 539. So, we have gone through what is authority, what are the different types of authority, actual authority, implied authority, Partnership Act, and few examples relating to implied authority. Thank you, students.